On behalf of the President, fellow judges, and the management and staff of the Caribbean Court of Justice, it is my great pleasure to welcome you to this instructional video on the referral obligation enshrined in Article 214 of the revised Treaty of Chaguaramas. The RTC establishes the CARICOM single market and economy, which creates rights and obligations for participating member states. Through these states, legal persons, businesses, and citizens of the Caribbean community have certain rights, and these rights are enforced by the Caribbean Court of Justice in the exercise of its original jurisdiction. An important avenue through which the CCJ may enforce these rights is by way of referrals to the CCJ from national courts and tribunals seeking authoritative interpretations of the provisions of the RTC. In 2000, Mr. Duke Pollard, who later became a judge of the CCJ, wrote the following in his capacity as Director of the CARICOM Legislative Drafting Facility.
The rights and obligations created by the CSME are so important and extensive, relating to the establishment of economic enterprises, the provision of professional services, the movement of capital, the acquisition of land for the operation of businesses, that there is a clear need to have a permanent, central, regional institution to authoritatively and definitively pronounce on those rights and corresponding obligations.
The Caribbean Court of Justice is that institution anticipated in 2000 by the late Justice Pollard.
In its original jurisdiction, the CCJ is an international court. It is the only court that has the authority to interpret the treaty when there are disagreements concerning the freedom of movement, trade and services, and movement of money within the Caribbean community, popularly known as CARICOM. In its appellate jurisdiction, it serves as a final court of appeal for 4 member states of the Caribbean community.
By interpreting and applying the revised treaty, which establishes the CSME, the CCJ will determine in a critical way how the CSME functions.
The agreement establishing the Caribbean Court of Justice was signed on 14 February 2001. The CCJ, in its original jurisdiction, has compulsory and exclusive jurisdiction to hear and determine matters concerning the interpretation and application of the provisions of the revised Treaty of Chaguaramas. Article 211 of the treaty indicates that such disputes may arise a. between CARICOM member states, b. between CARICOM member states and the Caribbean community, c. through the referral process per Article 214 of the treaty between litigants appearing before the national court, or d. from applications by persons per Article 222 of the treaty
when a matter is before a national court or tribunal and a question arises requiring the interpretation and application of the revised treaty. The national court or tribunal does not have the jurisdiction to provide that interpretation or application. Instead, the national court or tribunal must refer the question to the CCJ in its original jurisdiction and await the CCJ's interpretation before proceeding with the matter in the national court. This is called the referral process, and it is provided for under Article 214 of the revised treaty. In this training video, we will look at the step-by-step process of making the referral, from recognizing that a question of interpretation and application of the CARICOM law has arisen, to the national court or tribunal applying the CCJ's judgment on the question to resolving the case before it, and the implications for such CCJ judgments becoming precedent among parties to the RTC. The process is laid out in greater detail in the court's manual for referral proceedings, available at the court's website, www.ccj.org.
Module 1. Recognition of an issue for referral. When a matter is being heard in a national court or tribunal of a member state and an issue arises related to the interpretation or application of CARICOM law, the national court or tribunal is duty-bound to refer the issue to the CCJ, as the CCJ has exclusive and compulsory jurisdiction to interpret and apply the treaty. In contrast to appeals which seek to challenge a legal ruling already made in a lower court, a referral facilitates determination of an issue relating to the application and interpretation of the treaty, which arises in a case that is ongoing in a national court or tribunal. By ensuring that national courts and tribunals are clear on the interpretation and application of the provisions of the revised Treaty of Chaguaramas, the referral process supports uniformity and consistency in interpreting and applying existing CARICOM law across member states. Module 2. Decision to make a referral. Once the decision to refer an issue to the CCJ has been made, the proceedings in the national court or tribunal, that is, the particular case in which the issue arises, must be stayed until the CCJ presents its final ruling on the referred issue. Module 3. Hearing from the parties. The national court or tribunal may hear from the parties to the case in relation to the decision to refer the issue to the CCJ. The parties may be given an opportunity to make submissions. After this step, the national court may proceed to refer the issue if it considers it necessary to do so. Module 4. Initiation of the referral process and content of referral proceedings. Filing a referral begins with completing the prescribed referral form, available for download at ccj.org and at page 14 of the referral manual. The referral form includes the parties to the proceedings, the factual background, legal background, and the referred question or questions. This form is completed by the appropriate officer of the national court or tribunal. It must be signed by the registrar of the national court or the appropriate officer. The parties to the proceedings and referral request. This section outlines the essential features of the referral procedure. This includes the decision to make a referral, the subject matter of the referral, the form of the referral, the content of the referral, any ongoing communications between the CCJ and referring body, joinder of referrals where applicable, and the costs of referral proceedings. The factual background. The national court or tribunal must outline the facts of the case that is before it. This section helps the reader understand the origins, parties, actions, circumstances, and progression of the matter, and gives context to the issue which was referred to the CCJ. The legal background. The national court or tribunal should provide a brief description of the legal background of the dispute pending before the referring court or tribunal, and an indication as to why it requires the particular interpretation of CARICOM law. The referred question or questions. The national court or tribunal should clearly state the question or questions which the CCJ is being asked to answer. There is no limit to the number of questions that may be asked, provided A. They are relevant to the resolution of the dispute pending before the referring court or tribunal, and B. They concern the interpretation or application of the RTC or the interpretation, application or validity of a decision taken by a CARICOM organ or body. The completed form must then be submitted with any notarized supporting documents and additional information to the CCJ through its official e-filing platform. Module 5. Procedure after the referral is filed. According to Rule 10A.2(5) of the CCJ Original Jurisdiction Rules, within 14 days of the receipt of the referral, the Registrar of the CCJ serves the referral on Member States, CARICOM, and the parties to the proceedings. Where CARICOM or any Member State wishes to be heard on the question or issue referred, they must indicate this to the CCJ within 6 weeks of being served or within any period that the court may stipulate. The court will give directions accordingly. Where the court determines that the matter referred is outside its jurisdiction, it will inform the national court or tribunal accordingly, and reasons for this determination must be given in writing. Where the court has jurisdiction, it will proceed to answer the question referred. After the parties are heard by the CCJ, the parties will be given directions for the further conduct of the matter. This will include directions for any additional submissions, written or oral. Module 6. Conclusion of the referral process. After the CCJ has determined the answer or answers to the question or questions referred, it must give its ruling in writing. The registrar must send the ruling to the person who signed the referral, the parties to the proceedings before the national court, and anybody which made submissions to the CCJ on the referral. The referral judgment will then be published by the court for access by the general public. Module 7. Epilogue to the referral process. The referring court or tribunal must apply the ruling to the facts of the dispute pending before it and deliver judgment in that dispute. Upon delivery of judgment, the referring court or tribunal must send to the registrar of the CCJ a copy of the judgment. Questions and answers. If you have questions on any material in this instructional video, feel free to submit them in writing to referralqueries@ccj.org. If the tutorial is being delivered in person, you may pose questions to the officer or officers giving the tutorial. Please refer to the CCJ's Manual for Referral Proceedings for further details and explanation on this process. It should be noted that there are unique referral provisions in the applicable legislation in Jamaica. This video does not address these provisions, but a special note on the referral process in Jamaica is to be found in the manual.
And to mark this official launch, the CCJ is pleased to provide each participant to this 2022 casual conference with a hard copy of the manual. We hope sincerely that you have enjoyed viewing this video and that you have been sensitized to the referral process. Thank you for watching.